This is English Shorthand Dictation number 317, and the dictation speed is 120 words per minute. Ready? Start. The learned senior advocate appearing on behalf of one of the appellants accused has submitted that in the facts and circumstances of the case, the High Court has committed a grave error in quashing and setting aside the well reasoned order passed by the learned CJM dismissing the complaint under section 156(3) of the Code of Criminal Procedure. It is submitted that the High Court ought to have appreciated that the learned CJM dismissed the application under section 156(3) of the Code of Criminal Procedure upon verifying the truth and veracity of the allegations made in the application, more particularly considering the fact that there was a delay of almost 2 years after the date of the alleged incident, which has not been explained. It is submitted that the learned CJM was well within its jurisdiction to verify the truth and veracity of the allegations made in the application when such serious allegations were made after a period of almost 2 years after the date of the alleged incident, and that in between, though number of other complaints were filed against the accused and others, at no point of time any allegation of rape on 29/11/2018 was made. It is submitted that while passing the impugned judgment and order and quashing and setting aside the order passed by the learned CJM, the High Court has wrongly relied upon and considered or applied the decision of this court in the case of Lalita Kumari versus Government of Uttar Pradesh. It is submitted that the High Court has materially erred in observing that while considering the application under section 156(3) of the Code of Criminal Procedure, magistrate has no jurisdiction at all to verify the truth and veracity of the allegations. It is further submitted that the learned single judge of the High Court is not right or justified in taking a contrary view than the view taken by the coordinate bench in the case of Mukul Roy. It is submitted that if the learned single judge of the High Court was of the opinion that the view taken in the case of Mukul Roy is not a correct law, in that case, propriety demands that the learned single judge ought to have referred the matter to the larger bench rather than taking a contrary view. It is further submitted by the learned senior advocates appearing on behalf of the appellants that in the present case, even the SHO, after receiving the complaint in the month of October 2020, conducted a preliminary inquiry as per the law laid down by this court in the case of Lalita Kumari versus Government of Uttar Pradesh, and thereafter refused to register the FIR. Learned senior advocates appearing on behalf of the respective appellants have taken us to the number of emails and messages sent to one of the appellants from 30/11/2018 till March 2020. It is submitted that if he had committed the rape on 29/11/2018 as alleged, in that case, subsequently, there was no reason for her to send emails and messages to the appellant. It is further submitted that in between 29/11/2018 and October 2020, the complainant filed various complaints before various police stations against the very accused. The first complaint was filed on 12/12/2019. The said complaint categorically mentions that she met the appellant. However, the complaint does not make any mention of the alleged incident of rape. It is submitted that in the said FIR, the only allegations were that she was called by the top level leaders for 4 times in the last year, November 2018, and each time they locked her for 4 to 5 hours and pressurized her to withdraw the case. It is submitted that the said FIR was registered as FIR number 131 oblique 2019. It is submitted that the said case has been closed now, as a closure report dated 16/6/2020 was filed in the aforesaid case. It is submitted that thereafter another complaint dated 6/2/2020 was filed. However, there was no mention of any particular date of the alleged rape incident. It is submitted that thereafter one more complaint was filed on 12/3/2020, wherein she did not mention about the alleged rape incident at all. It is submitted that after a period of 2 years of alleged incident of rape, the complainant filed a complaint dated 27/10/2020, in which for the first time she stated that in order to pressurize her to withdraw the 2018 case against Amalendu Chattopadhyay, the appellants called her at the apartment of appellant number 1 and raped her on 29/11/2018. It is submitted that the learned CJM rightly observed that as there was an unexplained and inordinate delay of 2 years in making the complaint against the alleged offense, it casts doubt regarding the truth and veracity of the allegations contained in the application under section 156(3) of Code of Criminal Procedure. It is further submitted by the learned senior advocates appearing for the respective appellants that while passing order dated 12/11/2020, the learned CJM made some pertinent observations to highlight that there was an inordinate delay in making the first police complaint against the alleged offense, and that there existed sufficient inconsistencies to raise doubts regarding the truth and veracity of the allegations contained in the application under section 156(3). It is submitted that firstly, the learned CJM observed that according to the complainant, the alleged offense took place on 29/11/2018. However, attempt to initiate criminal proceedings was made for the first time only on 27/10/2020, the date when a complaint was lodged at the Bhawanipur police station. This was after a gap of about 2 years from the date of the alleged offense. It is submitted that the learned CJM further noted that the complainant in her application under section 156(3) has stated that she made several complaints before various police stations against the accused persons and their men for the physical attacks carried out on her. However, no such complaint finds mention of the alleged offense of rape. Therefore, the learned CJM noted that possibility of false implication cannot be ruled out, especially when the same complainant made several other complaints against the same accused in that period in which no allegation of rape on 29/11/2018 was made.